This pertains to the address in question, Waco, Texas, 76706. You, Ms. Chen, on behalf of the apartment complex, indicated in your petition, which is a sworn complaint, that the defendant, Ms. Brown, defaulted in the terms of her lease by not paying rent. At the time of filing, you indicated that she owed for November's rent, and that was $439. With that being said, we're going to have both parties sworn in, and we will proceed on with today's case. Raise your right hands. Do you solemnly swear and/or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And so what's going to happen next, ladies, I'm going to give you, Ms. Chen, the opportunity to speak first. You know, it's up to you to provide proof to me that the defendant, Ms. Brown, did default in the terms of her lease by not paying rent. It's also up to you to provide proof to me that you comply with all of the laws of this state as they pertain to evictions. Now, while Ms. Chen is speaking, I'm going to ask that you, Ms. Brown, refrain from interrupting her. I need to make sure I hear everything that Ms. Chen is stating. Okay, Ms. Brown?
Yes, sir.
Afterwards, once Ms. Chen is through, I'm going to give you, Ms. Brown, the opportunity to defend yourself. It's going to be up to you to provide proof to me that you should not be evicted for whatever legal reasons you can deem so, approve so.
The court session begins with the judge confirming that the case concerns an apartment located in Waco, Texas. He explains that the petition filed by the apartment complex accuses the tenant, Miss Brown, of failing to follow the terms of her lease by not paying rent. According to the complaint, the rent for November had not been paid at the time the case was filed, and the amount due was $439. The judge explains that the complaint is a sworn statement, meaning the information must be truthful and supported by evidence. Before the hearing continues, both parties are asked to raise their right hands and take an oath to tell the truth. Each person confirms that they understand the oath and agrees to testify honestly. The judge then outlines how the hearing will proceed, so both sides clearly understand the process. He explains that the apartment representative will speak first, because she filed the case. The judge also reminds both parties to remain respectful and avoid interrupting each other while speaking. This introduction sets the structure for the rest of the hearing.
And while you're speaking, Ms. Brown, I'm going to ask that you, Ms. Chen, refrain from interrupting her so I can hear everything that Ms. Brown is stating. Okay, Ms. Chen?
Yes, sir.
All right. With that being said, are there any questions before we proceed on with today's case?
No, sir.
Okay, Ms. Chen, you may proceed with your case, ma'am.
Yes, sir. So I have a lease agreement dated July 22nd for a monthly housing installment rate of $659. There is a concession of $220 per month, making the rent owed $439 per month. We do need to amend our petition to ask for November and December's rent, please. But outside of that, we do have an electronic signature on this document going until the end of July 2026 or July 21st, 2026. This was signed by us. The last payment we received for this housing installment was October. October 3rd. And so we have failed to receive any payments in November and December. And that is why we filed for eviction. We served a 3-day notice to vacate. It was hand delivered on the 8th of December.
Okay. I'm looking through some of the documents you provided to me. I see that you provided me with a copy of the notice to vacate. Looks like Mr.
The judge gives Miss Chen the opportunity to present her case on behalf of the apartment complex. She explains that there is a written lease agreement signed on July 22nd, which outlines the terms of the tenant's housing arrangement. The original monthly housing installment listed in the lease is $659, but the tenant receives a monthly concession of $220. Because of this concession, the actual rent owed each month is reduced to $439. Miss Chen tells the court that the apartment management now wants to amend the petition to include unpaid rent for both November and December. She confirms that the lease agreement was signed electronically and is valid until July 21st, 2026. The apartment complex also keeps a record of all payments made by the tenant. According to their records, the last payment received from Miss Brown was on October 3rd. Since that time, the management states that no payments were received for the following months. Because of the missed payments, the apartment complex decided to begin eviction proceedings.
Whittington was the person who actually delivered this, is that correct?
Yes, sir.
Okay. And I also have, looks like it's a summary, it's a ledger, which details all of the transactions, and this is up until December 7th. And as stated in your testimony, the last time you all received a payment, you said October 3rd, but it does say from October 3rd right here. $195, I see that. The next document I have in front of me is a lease between you and the tenant. It does indicate that it was executed on or around July 22nd of 2025. Everything was done electronically. And it does detail the terms of lease, as you stated on the road. All right. And anything else before I move on to the defendant?
No, sir, just that we have not received payment as of right now, and we are seeking eviction.
Okay. All right, Ms. Brown, here's your opportunity to defend yourself. Tell me why you feel like you should not be evicted from this unit.
I don't have a problem with being evicted. I'm currently packing and moving out. It is taking a lot longer than I expected because I don't have a vehicle to move stuff, and I don't have anyone helping me. The reason I didn't pay the rent, I didn't get my full Social Security check. I'm on disability, so I only get one check once a month. And I informed them that I didn't get the full payment, and they said that I had to pay the whole thing before it got the eviction notice. And I don't have that amount of money. And I've tried to ask people to help me, but I don't have that much family. And so I'm moving out. I'm not trying to stay here any longer than necessary. I just have a hard time packing because I don't have any transportation. The car that I received from my mother when she passed away, the tags are out and I don't have a driver's license. So,
Ms. Brown, have you been here before?
yes, sir. I was here a couple of weeks ago, maybe.
Miss Chen continues explaining the steps taken before filing the eviction case. She states that a 3-day notice to vacate was delivered to the tenant as required by state law. This notice informed the tenant that she needed to leave the apartment or resolve the unpaid rent. The notice was hand-delivered on December 8th by a staff member named Mr. Whittington. The judge reviews the documents that were submitted as evidence, including the notice to vacate and a payment ledger. The ledger shows a summary of the tenant's payment history and confirms the last recorded payment in early October. The judge also examines the lease agreement between the tenant and the apartment complex. The document confirms that the lease was executed electronically in July 2025 and outlines the rental terms that both parties agreed to. After reviewing the documents, the judge asks if there is anything else the apartment representative wants to add. Ms. Chen responds that the rent remains unpaid and that the complex is seeking eviction.
2 weeks ago, but the situation hasn't changed for me. I don't really have help. My fiance works every day except for weekends.
Correct me if I'm wrong. Ms. Chen, what happened with that case about 2 weeks ago?
I think it's because they didn't give me the eviction notice the right way, so we
Proper
had to.
notice to vacate. Okay.
Yes, sir.
Okay. So this time around, they did give you proper notice.
Yes,
Okay.
sir.
All
He
right.
did hand it to me.
Okay. That was the problem last time. So I didn't mean to stop you, but
Oh no,
it's
it's okay.
Groundhog Day. I heard this your response from the last time, and it again. I heard it. So there's no really defense. It's just that you just having a hard time getting everything moved out. I heard,
Yes, sir.
you telling me about your fiance and about your financial situation. I was just wondering, I said, I know I heard this case, before, but now, I remember what happened in
Yes,
regards to
sir.
it. Okay. All
But
right.
that's the only thing. Like I'm trying to get out as soon as possible. I'm not. I don't have any funds to pay the rent. I didn't get my full check this month. All the money is going towards working on the RV that we have. But other than that, I'm trying to get out as soon as possible.
Okay. Okay. Based upon everything that I've heard today, I'm going to rule in favor for the plaintiff, for possession of the property in question, 2826 South University Park Drive, apartment 928C is in Charlie, Waco, Texas, 76706, as well as back.
The judge then gives Miss Brown the chance to explain her situation and defend herself. She calmly tells the court that she is not trying to stay in the apartment permanently and is already preparing to move out. However, she explains that the process is taking longer than expected because she does not have a vehicle to move her belongings. She also says she does not have many people available to help her with the move. Miss Brown explains that the main reason she stopped paying rent is because she did not receive her full Social Security disability check. Since this check is her only source of income, the reduced payment made it impossible for her to pay the rent. She says she informed the apartment management about her financial situation but was told she needed to pay the full amount. She adds that she has tried to find help from family or friends but does not have much support. Despite the difficulties, she insists that she is trying to leave the apartment as soon as possible.
Branding amount of $878 is $439 for November, $439 for December, plus court costs, which is an addition of $144. You, Ms. Brown, have the right to appeal. Your appeal bond is set at $878, and you have 6 days from today's date to appeal. In the event that you do not appeal on or before that sixth day, and if you are still occupying the premises, then at that time, you, Ms. Chen, may, on behalf of the Grove at Waco, file a writ of possession. A writ of possession is where the constable will serve you with a final notice, giving you 24 hours to move out. If you do not comply with that 24-hour notice, then at that time they will be back over there within the time frame, with an agreed upon date and time with Ms. Chen. I want to make sure that I'm clear. After you are served with the 24-hour notice to vacate, Ms. Chen and the constable's office will have an agreed upon date and time to meet back over there. They will not notify you of that date and time. It's something that they would agree upon. It could be 6 in the morning, could be 7 in the morning, it could be noon. Don't know the actual date. That is the only people privileged to that information would be Ms. Chen.
The judge asks Miss Brown whether she has appeared in court about this matter before. She confirms that she had previously attended a hearing about 2 weeks earlier. The judge then asks Miss Chen to explain what happened during that earlier case. Miss Chen explains that the previous eviction attempt was dismissed because the tenant had not been served with the notice correctly. This time, however, the notice was properly delivered. Miss Brown confirms that she personally received the notice when it was handed to her. The judge says he remembers hearing the earlier case and recognizes that the situation has not changed much since then. He acknowledges that Miss Brown is facing financial hardship and transportation problems. However, he also notes that she does not appear to have a legal defense against the eviction itself. Miss Brown repeats that she simply needs more time to finish packing and move her belongings out of the apartment.
In the constable's office. And so you may get a surprise, and the constable is going to be there, and they're going to make you come out. And then at that time, the maintenance personnel will be able to safely and peacefully remove all of your personal belongings from inside of the unit and place them outside of the unit. And so I just want to make sure you're clear, that I'm clear on this. You do have the right to appeal. But if you do not appeal and you do not honor the notice given to you after the writ of possession has been filed, then the constable will be back over there to execute it. Do you understand, Ms. Brown?
Yes, sir. So I have 6 days to get everything out.
You have 6 days to appeal, and if you're still staying there after the appeals date has expired, the constable will give you a 24-hour notice to move out.
And is the appeal for paying the back rent or is just to...
The appeal is disagreeing with my judgment today. That's
Okay.
what the appeal is. Okay. Any questions?
I do have a concern because they told me that my rent that I would owe was close to $2,000. If I had known it was only $800, I would have found a different way to pay it. But they told me,
Let me explain. I do not award late fees. I do not award utilities.
mhm,
And any other fees that may be charged upon you, that's something that I do not honor in a judgment. The only thing that I can honor is the back rent and court costs. So
okay,
whatever amount that they are telling you you actually owe them, that is purely between you and them. However, the judgment legally can only be for back rent and court costs and maybe attorney's fees. Okay?
okay. If I would
Uh,
have known that, I would have had the 800. I had the 800.
Brown, you're not understanding. Okay, let me see if so here's what I'm trying to tell you. In court, the judgment is only for back rent and court costs and maybe legal fees.
Mhm.
But the amount you actually owe them is totally different.
Okay,
Okay, so what you actually owe them is more than the judgment amount.
okay,
All right. So even if you would have taken $878 to them, you would have still been evicted because it's not what you actually owe them. I can only grant them judgment for back rent and court costs, not for late fees, not for utilities or any other fees that you had agreed upon in your lease.
okay.
All right. Okay. All right. That being said, judgment favor.
After listening to both sides, the judge announces his final decision. He rules in favor of the apartment complex and grants them possession of the property. The address of the apartment is confirmed as 2826 South University Park Drive, apartment 928C, in Waco, Texas. The judge also orders Miss Brown to pay back rent totaling $878, which represents $439 for November and $439 for December. In addition, she must pay court costs of $144. The judge explains that Miss Brown still has the legal right to appeal the decision if she disagrees with it. If she chooses to appeal, she must file the appeal within 6 days and post a bond equal to the rent owed. If she does not appeal and remains in the apartment complex can request a writ of possession. This would allow law enforcement to give her a final 24-hour notice to move out. If she still does not leave after that notice, the constable would return and remove her belongings from the apartment. The judge makes sure she understands the process before closing the case.